A new book, numerous articles, and even a 60 Minutes report on congressional insider trading has renewed public support for the Stock Act, or Stop Trading on Congressional Knowledge Act. Joining me now to discuss this legislation and perhaps its unintended consequences for the financial industry are Emily Pataki, a Bloomberg Law legal analyst, and B&A's legal editor, Maria Lokshin. Welcome to you both.
Great to be here.
So, Maria, as I mentioned in the intro, there's a lot of talk, a lot of chatter about congressional insider trading. But is there evidence that lawmakers in large numbers are trading on non-public material information?
There is not evidence of this. House Financial Services Ranking Member Barney Frank, when he pushed for the committee to consider the bill a couple months ago, he actually said, I am not sure how widespread this is. And Senator Coburn in the Senate Homeland Security Committee has actually also said that this is not a widespread practice. So it's really unclear.
Well, is the call then for regulation based on this public perception then that there's rampant congressional insider trading, whether or not there actually is?
I think that it is based more on perception, and that's at hearings that I've been to on the Hill, time and time again, that's what lawmakers have said, that there is this perception and we have to fix this perception.
Well, and so what do you think, Emily? Do you agree?
Well, recently you mentioned the book that came out. There have been numerous news stories that came out recently telling anecdotal stories of certain trades that happened over the healthcare debate for certain senators and over the economic crisis in 2008 for certain congressmen. When you look at certain trades and legislation and policy decisions that were made at that time, it tells a very compelling story. Also compelling is the fact that the SEC or the Justice Department have never actually prosecuted a member of Congress for insider trading. Members of Congress have gone to jail on other kind of bribery, fraudulent acts, but never for insider trading.
Wow, so there's no precedent in that area then. But let's talk about members of Congress then who are actually engaged in insider trading. Are they immune or exempt from the laws that prohibit this practice?
Well, there was a lot of discussion this past December in the Senate and the House. They both had hearings, as Maria mentioned, over that question. Is the law very clear? Are there ways to improve the law? The law right now is a series of SEC rules and judicial opinions. And when you mix them all together, sometimes it's clear and sometimes it's not.
It gets a little convoluted at times,
right,
I guess.
And so the Stock Act is, in its various forms, attempting to fix that ambiguity.
Well, so what are you saying, and I'm going to turn this to Maria then. Maria, though, are congressmen immune or exempt from the laws that prohibit insider trading? Yes or no?
I don't think that any... No, they are not.
Well, and
I think
okay. Go ahead.
I think that it's not really a yes or no question because congressmen have, they're protected by certain constitutional immunities that make it difficult.
And I want to get to that because I will say, though, Rob Khuzami, who is the SEC enforcement director, he says flat out, no, there's no immunity here for, the members of Congress. But he said that there are some unique issues that could come into play. And Maria, I think that you were about to get to some of those issues. So what are some of those issues that can come into play when a congressman is actually charged with insider trading?
Well, first of all, it's very hard to differentiate what is and what is not material non-public information. Second of all, it's not clear whether congressmen have a duty to keep that information confidential. And that Khuzami has actually said that that is the number one thing that is important to establish in an insider case. And the other issue that comes in is the so-called speech or debate clause, which basically says that anything that members of Congress say within the course of their public service cannot be used as evidence to prosecute them. So that together, creates a very big challenge for regulators and prosecutors.
Well, and Emily, insider trading is premised on the breach of a duty. So is there a fiduciary duty for Congress? I know that there's a code of ethics for Congress. Does that create a fiduciary duty for them?
There are hundreds and hundreds of pages of ethical rules that apply to the House and the Senate and to government employees in general. Dating back before the Constitution, there has been an expression of public service being a participation in a public trust. But when you look at it not in such an ineffable way. But if you actually look at congressional liability in terms of fiduciary duty, that's where the problem of prosecution comes. And that's why certain professors within the securities academic field are saying we have to spell out this duty of confidence and trust. And once that duty is clear, that it applies to members of Congress and to their staff, it'll be much easier for the SEC or the Justice Department to make a case for insider trading.
Okay, and Maria, Emily already stated that there's no precedent for prosecuting members of Congress, but is there a precedent for prosecuting federal employees on insider trading charges?
There is. Actually, there was a recent case where an employee of the Food and Drug Administration was prosecuted and sued by the Securities and Exchange Commission for trading on information regarding drugs in pharmaceutical company stock. But, if I may, I just want to add that, the FDA is a very unique case because their stocks of pharma companies depend very heavily on, whether certain drugs are approved or not approved by the FDA. So that's one thing. The other thing is that, there is a very clear, I think, duty in certain agencies, and I think that may be the case in the FDA, to keep certain information confidential.
Okay, so there's a duty there. And I understand what you guys are saying, and I understand that there is some ambiguity here, which is why some folks are calling for specific legislation on regulating congressional insider trading. So what has Congress drafted to date? What have they come up with to police themselves, so to speak, to date?
I think it's a really interesting story, going back as late as 2006, and every Congress since then has introduced this Stock Act, which you're talking about. Currently, there's a Stock Act in the House, and there are two, at least, in the Senate right now that are being revised and reworked based upon the hearings that they had in December.
Okay, for our conversation and our discussion, let's focus on the Stock Act that came out of City Committee in December, and then also the act that was reintroduced in the House in March 2011. So
Sure.
Are the bills similar, or are they significantly different?
There are a lot of similarities. I think the Senate bills have a little more viability right now. They've got a lot of strength behind them in terms of support. That's not to say that the House one doesn't. It actually has 245 co-sponsors.
That's a lot of folks.
But it's been criticized by some leading academics who have covered insider trading for decades.
Well, before we get to the criticism, Maria, can you tell us, what does the Senate bill entail? What does it hope to accomplish?
Sure, if I can just add to what you said, Emily, I think the Senate bill is very different from the House bill, and the reason that is because the Senate bill really very simply plays off of what Rob Khuzami and academics have said, and it basically just states a duty. It states that members of Congress have a duty of trust and confidence not to trade on material non-public information gleaned through their service.
So it makes this.
The other piece.
I was going to say, so it makes
ahead,
the
I'm
duty.
sorry.
It makes the duty clear then, because I know in the beginning we were talking about how there may or may not be a duty for Congress, but this bill makes it clear that there is a duty for Congress. Is that what you're saying, Maria?
Absolutely, yes, that's what it does.
I'm sorry, I was speaking to the public versions of the Senate bills, and so we are still waiting to see the revised version of the Senate bill that will encapsulate that duty language.
Okay. And Maria, if you could continue.
Sure, and I think the other piece of the Senate bill that's very interestingly different from the House bill is that the Senate Homeland Security Committee, Senator Lieberman, who heads that committee, actually decided in his chairman's draft of the new proposal that's out there to take out the piece that focuses on so-called political intelligence. And instead of the House bill basically says, we are going to bring these so-called political intelligence firms under, the eye of Congress. The Senate bill directs the Government Accountability Office to study the political intelligence firms more and how the trading on political intelligence affects the markets and other questions that are similar.
Well, and Emily, how does the House bill attempt to regulate political intelligence firms?
Well, right now, political intelligence firms, actually some of them say on their websites that they're not compliant with lobbying disclosure rules, and so they are able to keep more client information confidential, and that's an asset for them as a very profitable business. What these bills, certain versions of them would do, would be to apply the Lobbying Disclosure Act to intelligence firms. This has never been done, political intelligence firms. This has never been done before. It's literally inserting the phrase political intelligence firms in certain ways throughout the Lobbying Disclosure Act, and requiring periodic disclosure lists of clients and those.
Well, what's the disclosure regime exactly, and who must comply with it?
It would be applicable to government intelligence firms, political intelligence firms who have these contacts with members of Congress. And it requires actually disclosing the issues that you're working on and your clients' names. And it's periodic and also annual disclosure information. There's other things as well.
Right, of course. I know that the political intelligence is defined, or the contact is any communication, oral or written, between to and from a covered executive or legislative branch official. Maria, do you agree that this language, this bill and this language, is very similar to the laws that we already have for federal lobbying activities?
It is. It is similar, but I think one, if I may add, I think one piece that is not similar is, sources that I've talked to say that it's very unclear how many investment advisors really use political intelligence to inform their trades. And, the source that I spoke with, who's familiar with the matter, said, that it's likely only very large firms, and it's likely a very small percentage of firms that actually rely on political intelligence.
You're, Maria, and I hate to interrupt you, but you're saying that so this bill, as drafted, has the impact. It could impact not only members of Congress and federal employees, but could also impact investment advisors and other folks in the financial industry, albeit not significantly. But you're saying that there could be an impact to those folks as well.
Sure. I mean, it's the investment advisors that pay political intelligence firms to sort of mine this information from Congress. So, down the chain of getting this information, it will at some point impact investment advisors, is what I'm hearing.
Wow, that's pretty incredible. And what's the likelihood of this bill sort of passing, either one of these bills? I mean, as you mentioned, one of the bills in the House has been around since 2006, so I know little support then, more support now. What's the likelihood of them getting signed into law?
Well, I am sure Maria also witnessed this, but I got the sense that Chairman Lieberman of the Homeland Security and Government Affairs Committee that is actually working on the revised Senate bill was very motivated to push this towards passage. We see a lot of support for the congressional version as well. What will happen with the Lobbying Disclosure Act portion? We hear that the Senate is going to have a separate hearing on that, and so it remains to be seen what the details of that aspect of it will be. But I know that there are a lot of organizations throughout the country and in certain states where these elected officials who are kind of outed in the book reside that are pushing for this kind of legislation. And in some ways it seems like common sense. In some ways it seems like good politics. Mm-hmm. This is a very important election year. And yes, so there's a lot of motivation on both sides of the aisle.
Oh, great. And Maria, do you think that either one of these bills actually solve the problem, the perceived problem of congressional insider trading?
I think it remains to be seen, and for what I've heard from experts who've testified on the hearings, at the hearings on the Hill, is that in some cases the House bill, especially I think as written, can do more harm than good in terms of the application of insider trading laws to everybody, not just members of Congress, and it may actually work in competition, work against the insider trading laws. So, I think just to also touch on the point that Emily made, I think that the House bill is going to be significantly revised before it sees any sort of floor action. So, yeah.
Okay. Well, I have to say thank you to you both for your insight. We're going to have to leave it there. This has been a very interesting conversation, to say the least, and we're going to all stay tuned to see what happens with either one of these bills. That is Bloomberg Law's Emily Pataki, BNA's Maria Lokshin. For more information on this or other topics, log on now to BloombergLaw.com. I'm Spencer Mazyck, reminding you to be in the know with B-Law. Bye, everybody.